Going to be your next review hearing, 9 a.m. Any questions?
No, sir.
See Mr. Major, his office is to the left as you leave the courtroom.
Okay, thank you so much.
You're welcome.
State of Ohio versus Joseph S. Cutt. Case number, excuse me, Your Honor, these are pre-trials, so it's all
Okay.
agreements we have ready at this point.
Okay, so we need the prosecutor and the lawyers to come on.
State of Ohio versus Joseph S. Cutt, CRA 2259, PRC 2048, A, B, and C.
Mr. Steyer's case. Okay, I think this is actually, or is an arraignment.
Your Honor, Mr. Cup was scheduled to be here on the 24th. He didn't make it in. He contacted me this weekend and asked, when he could get in here. I told him the sooner he could get in, the better, and he appeared this morning. I don't have my file with me, and I'm certain the state doesn't have their file either. I spoke to him during the weekend, so at this point, I'd just like to ask that the warrant be withdrawn and that we be given a new date and have him back in here when we can have the case ready to actually look at.
Are you still at OVP?
Yes, sir.
Okay.
Almost 7 months clean, Your Honor.
All right, very good. When do you want to come back, Mr. Steyer?
What kind of time frame would be good for the court? I know I'm not here the 17th, but
Pretty much
other.
any time in May. The 12th is actually the busiest day in May, so.
Want to go into May? I'm free May 1.
May 1st. And it'll be preliminary hearing and pretrial, May 1st.
Thank you, Your Honor.
Right.
10 o'clock.
State of Ohio versus Brian Fuller, case number CRB 22666.
Mr. DeWater's case, Brian Fuller.
Brian Fuller.
I just talked to Mr. Fuller.
Here or on the phone?
No, here, and he,
They might have walked outside to smoke. Two guys.
Recall.
well, I don't think he smokes.
State of Ohio versus Stephen T. Wells, case number TRC 222615, A, B, and C.
All right, I had this down. This was set for an evidentiary hearing, is it resolved?
It was, we resolved this, Your Honor.
Yes.
It's my brother's side to side. He has insurance. They ain't even contact me. They, hey, I think what it was, dude, the guy that had still, he didn't have insurance on his criminal car. They went after him.
Is there a Brandon Freeman or a Phelan Boley here today? Boley or Freeman? Okay. I think there was a request for police. What the works over. Since they were subpoenaed, I don't feel comfortable doing it until I know if they're gonna be here. I don't like to go ahead and reduce it. Unless we can get hold of it. All right, this case it was scheduled for noon. There's some witnesses subpoenaed, so I'm going to delay it until noon unless those witnesses can be called off. This case will be recalled.
State of Ohio versus Austin Neese, case number CRA 2385, CRA 2386.
This is Mr. DeWaters' case set for preliminary hearing, actually.
Yeah, Judge, it's my understanding the state is willing to dismiss the charges that are pending on the condition that Mr. Neese forfeit the firearm that was confiscated. There was also a telephone that was confiscated that Mr. Neese will not be getting back either. There's a misdemeanor menacing charge and then a felony firearm charge.
Mr. Hill.
That's our request, Your Honor.
In this case, there was complaining parties also. Were they consulted on
Yes.
this?
Yes, Your Honor.
That was Ethan Collins.
That's correct, Your Honor.
All right, on CRA 2385. I'll allow this case to be nollied upon the firearm be forfeited and order destroyed, and the firearm, we have
Your Honor, the only description is Glock 19X 9mm. I'm not able to find a serial number, anything here.
I don't see one in the affidavit.
Nor is there one in the sheet where they collected property.
Okay, and then also the aggravated menacing will be knowledge.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Brian Fuller, case number CRB 22666.
Mr. Waters' case for pretrial.
Judge, this is a case that was on a 90-day continuance. We had an agreement that the case would be dismissed today if there are no further problems. I don't think there have been any further problems. However, I was advised today that the complaining party had retained a lawyer to help her with issues related to the civil protection order and things of that nature that are involved between these two people.
Well, I have a note that on January the 9th, she requested the protection order drop.
She did, but there is also a civil protection order case that has not been dropped.
Okay.
So that's not in your court, that's pending down in common police court. I don't know if we can proceed today and go ahead and conclude this part of it or not.
I believe that because of the fact that there's some question as to the status of the protection order case in common police court and the intention of the parties and things of that nature, that we would not want to dispose of the case today. But we would, it's my understanding, Mr. McCown is involved with the victim in securing the protection order. So we want to have some time to see how that plays out. And that can have an influence on how we want to proceed in this case.
Is there a hearing set?
There is Thursday.
Oh, this coming Thursday?
Yes. I don't care. Can we do this, Judge? I don't know how that has any impact on this, because our agreement in this case was that the charges would be dismissed, and I think the alleged victim was here asking for that. But if Mr. Hill wants to wait until after the hearing on Thursday, Mr. Fuller is probably okay with that. Just, can he not have to be here unless there's some, if there's some good reason for him to come back to court and miss work again, fine, he'll be here. But I wonder if we could set it for one more hearing and not require his attendance, because I have a feeling it's all going to be resolved.
Mr. Hill?
We're not opposed to that.
Could we do it on May the 1st?
Yes. Case will be dismissed then if there's no further problems and the common pleas matter is worked out. If there's issues involving it, then this case may remain.
Okay.
If it's going to be dismissed, it can be done without his appearance.
All right, thank you, Judge.
State of Ohio versus Amber D. Ward, case number CRC 2316, A and B. Amber Ward.
Yes.
Prior to coming into the courtroom, Miss Ward is stuck in North Carolina. I don't know the details. I just know she phoned the office and advised me of that.
All right, defendant agrees to waive time and the state agrees to continue to May 1st at 10 o'clock.
Thank you, Judge.
State of Ohio versus Taylor Permitter, case number CRA 23189, A and B, and CRB 23191.
And Judge, I talked to Mr. Hill about this. This is a case where I think the prosecutor's office is going to be potentially agreeable to resolve the felony cases in your court. However, that is going to be dependent on Ms. Parmiter's continued positive efforts in treatment. She's currently with Bethesda in an inpatient setting. and my understanding is she's doing good, she's doing well there. However, she's very early on in this. So we'd ask that you reset this at a later date so we can assess her continued progress. Maybe even May 1st, that's 3 weeks away.
Your Honor, the circumstances of this are a little bit even more troubling than a typical case in which someone's in treatment because of what happened. We've been advised that she's been through treatment several times and goes right back to using again. And we need for her to take this very seriously from here forward and not make even a little mistake. Otherwise, we will take the case to the grand jury and we'll make every effort to give her as much punishment in this as we can. Right now, we want there to be treatment, but we're not opposed to seeking her to be punished to the extent that we're able if she's not successful. We've got an endangering children charge here that we take very seriously. So jail would definitely be something we would be seeking if she's not compliant completely this time around.
It's my understanding she also has an ankle monitor at this point, is that correct? Okay. So we want to keep that currently?
Yes, Your Honor.
All right. The ankle monitor will remain. Continue with your treatment. You got a good report from Bethesda, so you can do this. And you need to keep doing it and do it not only for yourself, but I understand you have children. And yeah, I'm sure this is common sense, but I just recently went, and so Mr. Heald and some others, we went to a seminar where we were educated about the adverse impact this has on your children. You using substances has an impact on your children. And, I mean, it's common sense, but look, the more you have a problem, the more likely it is that your children are going to have a problem down the road with substances. You don't want that, do you?
No, sir.
So if you need that extra motivation, it's not just about you anymore. You may say, well, I don't really care about me. Well, you care about what happens to your kids?
Yep.
Because what you do affects them too. So, and we're finding out that it's not, this is the thing that I learned new recently. I used to think, well, if they're little babies, 0 to 3, they don't know what's going on. It's not having a big impact on them because they're not really aware of the circumstances. That's wrong. That's when the most impact happens. 0 to 3 is 80% of the brain development in your child occurs in that first 3 years. So, you not being in the home, that's an adverse impact on your child. You using substances, that's an adverse impact on your child. Those are two, they call it ACEs, adverse childhood experiences. The more your kid has, the more likely it is they're going to wind up using substances themselves. There's 10 potential ACEs that you can have. Those are 2 of them. Your parents use drugs. Your parents aren't in the home with you. There's 2 right there. And the higher the score is, the more likely it is that your kids are going to use drugs down the road. Yeah, it is. It's emotional. It should be. It's sad. And this area has, the average ACEs score in the United States for children is a half, 0.5. Not 1, but a half of 1. The average ACEs score in the tri-state is almost 2 for kids. So that's why we just keep perpetuating the problem. One generation does stuff to the next generation, and they pass it on, and then they wind up using it. So we got to break the cycle. So you're the only one in front of me, but I feel like I'm looking at you and I see you got 2 kids?
Yes.
I mean, I I wish they were here in a way, so I could look out for them and do some stuff to protect them. But I can only do it through you, because I don't have jurisdiction over them, the way our system works. But I can call Children's Services in if you think that'll help. Are they involved with your kids?
Yes,
They're already there.
yes.
And I believe that her parents are very much involved also, Your Honor.
Okay, well, you're lucky to have, so we got that situation a lot. A lot of grandparents are stepping into the breach and doing the job that the parents should be doing. But you need to get your act together and you be the mom. That's what your kids want. They want you to be their mother. Okay, let's come back May 1st and see where we are. Get a good report. And whatever motivation you need to find it in yourself to do this. May 1st. Let's get a good report.
Thank you.
You're welcome.
Chris.
Okay, we have some more arraignments to do.
State of Ohio versus Sarah Osborne, case number CRB 23164, A and B.
All right, Mr. Morford, you're going to be representing yourself.
Yes, I've been retained representative, Your Honor.
Do you waive a reading?
So waived.
I'll enter a not guilty plea. She can sign a $1,000 signature bond. Do you have a preference as to hearing date?
No, Judge, you probably know that this is also on the second floor. She has a children's services case going on as well.
Okay.
Your Honor, I believe we've already had her maybe currently pending case, unless I'm wrong, of similar circumstances. No?
Does she have any cases pending now?
She's saying no, Judge.
Okay.
Okay, I'm mistaken, and I apologize.
Do you have a preference for a hearing date?
No, Judge, whatever's best with your doctor.
May 1st?
That's a good day.
May 1st will be the pre-trial at 10 o'clock. She can sign a signature bond, $1,000.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Stuart Shepherd, case number CRB 23221, A and B. Companion case, State of Ohio versus Anna Shepherd, CRB 23220. And Caleb, State of Ohio versus Caleb Blake, CRB 23222.
You're welcome. Stand up there together. All right, so we got Stuart Shepherd, Anna Shepherd, and Caleb Blake. All right, Mr. Shepherd, you got 2322A is a domestic violence complaint, alleges that April the 8th of 23, in Rome Township, you knowingly caused or tried to cause physical harm to Anna Shepherd, who's a family member of yours. That's a domestic violence charge, first degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. 221B alleges April 8th, Rome Township, you knowingly caused or tried to cause physical harm to Caleb Blake. That's an assault charge, first degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. How do you plead to your charge?
Not guilty.
All right, Hannah Shepherd, that's you, ma'am. 23220 is your case number. You have a domestic violence complaint alleges April 8th. 8th, you knowingly caused physical harm to Stuart Shepard, who's a family member of yours. First degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand that charge, ma'am?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead?
Not guilty, Your Honor.
And then Mr. Blake, 23222. You have an assault charge, April 8th, Rome Township. It's alleged you knowingly caused or tried to cause physical harm to Stuart Shepard. That's a first degree misdemeanor, maximum penalty 6 months in jail, $1,000. Do you understand the charge?
Yes, sir.
You understand your rights?
Yes, sir.
How do you plead?
Not guilty.
Do any of you want to be considered for a court-appointed lawyer? If you do, I have to ask you about your income.
No.
No. I have one that I will be hiring.
Okay, Ms. Shepard, who's your attorney going to be?
It'll be J.T. Holt.
J.T. Holt? Okay. What about you, Mr. Blake?
I as well, J.T. Holt.
All right, you'll be representing both of you.
Yep.
Mr. Shepard, have you hired an attorney?
I talked to Cremines, he just couldn't be here today.
Okay. All right, so I'm assuming all of you probably work.
Yes, sir.
Yes.
Mondays and Fridays are when we have court. Do you have a preference that we can agree on a Monday or Friday for the next hearing date?
Just in advance. Either one.
Mr. Shepard?
Friday.
Friday's better for you, Ms. Blake?
Monday.
Okay, well, then I've got to flip a coin then. Because it makes sense to have the cases all set on the same date. So your attorneys and the prosecutor can all talk about the cases at the same time. So, okay. Mr. Blake, I'm thinking of a number between 1 and 10. What is it?
7.
3.
It is 3. So I'm going to set it on the 19th, May 19th. It's a Friday. And you all can sign a signature bond. You have a right? Okay. They all have a bond already, so we'll just continue the bond they've already posted with Mr. Sowers. Do we need protection orders? Do you want ordered Mr. Shepard stay away from you all stay away from him? Do we need that?
I don't.
I don't. I just need my children back.
Okay, well, where are they now?
My house.
They're with
Okay.
him.
Well, I'm assuming there's some sort of visitation order and custody order?
There is. It's supposed to be 50-50, and they're supposed to be at my home.
Okay, well, I'm going to recommend that you go back to whatever the visitation order is. Now, I don't have jurisdiction over that, so what would happen if you can't agree on it? I mean, how much do you want to lawyer up on this stuff? I mean, it gets expensive if you're going to disagree about everything and have to have lawyers fight it out. But that's what would have to happen. You'll have to go back to common pleas court, which I'm assuming this is in a divorce order?
Yes, sir.
The custody and visitation order. That court has jurisdiction over the visitation and custody and those issues. I don't have, but I can try to facilitate it. I would just say, look, let's try to go back to make it as normal as possible for your kids. It's really back to the same thing I talked about before with the young kids and drugs. I mean, let's keep things as normal as possible for the kids. I mean, you all can fight, but don't do it in front of them. They don't want to be involved. They don't want to be adversely affected. They want to love everybody. They don't want to take sides. Don't make them take sides. I've been through this myself. I was divorced and I had kids. So try to, sometimes you got to take one for your kids. Try to keep it normal. Try to keep it on an even plane. And if you can't, you're going to have to go back to court down in common pleas and let the judge down there make an order about what you're going to have to do. If you think, well, that visitation order or custody order doesn't work anymore because of some change in circumstances, that court's gonna have to make the order to make the change. I can't change that order. Now, I can order you all to stay away from each other while this is pending, but it doesn't sound like you all want that. I'm hoping this was kind of like, I don't want to prejudge, but I'll just say this was a blip, and we're gonna get back, we're gonna get up here, now we're gonna get back down to where things are more calm and even, okay? Is that an assumption I can make? We're gonna keep things nice and calm
Yes, sir.
before we come back to court? Okay, so we'll do that. So you all can talk. Now, I'm not gonna worry you stay awake, but I suggest you just talk about what we're gonna do on visitation, custody, and try to work that out. Make it as easy as possible for your kid. I don't know if there's more than one, but whatever, the child. There has to be some minors involved here. Okay, May the 19th is going to be the next hearing at 10 o'clock for pretrial. Any questions?
No, sir.
Okay, that's all.
State of Ohio versus Lindsay Wiley, case number CRB 23223.
Name, are you Lindsay Wiley?
Yes.
Ms. Wiley, it's alleged that in Fayette Township on April the 8th, you deprived or tried to deprive Walker of property without their consent. That's a theft charge. It's a maximum penalty of 6 months in jail and a $1,000 fine. Do you understand the charge?
Mm-hmm.
Do you understand your rights?
Yes.
How do you plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
Yes, please.
Do you have a job?
I know I'm in nursing school.
You have no income right now?
Mm-mm.
I'll appoint Mr. Steyer to represent you.
Okay.
He's right behind you. And I'm going to enter a not guilty plea for you, Ms. Wiley. She can sign 1,000, let's see, she may have posted, she did post a bond. Your bonds continued that you posted.
It means you have to get out of jail.
Preference for a hearing date, Mr. Steyer?
We used the first a moment ago. That would work. We can still do that.
All right, May 1st. May 1st for pretrial, 10 o'clock. She's already posted one.
So back here.
Okay.
Yeah, but don't leave if you don't mind. Go ahead.
State of Ohio versus Ethan R. Anderson, case number CRD 2319.
All right, this is Mr. Stratton's case, and you had a chance to talk with Mr. Anderson.
Yes, Your Honor. He's at Stillman Reeds.
Yep.
Yes. I think we just want to bump this along. He still's got this felony case pending with Mr. Smith, and we're just going to continue this along. Do we have a letter from Mr. Reeds?
I've had some exigent circumstances happen this morning, Your Honor. I had his report on my desk. I forgot it. However, I do have a picture of the report if it requires.
You can just give me a verbal if you...
Okay, he's complying. He's doing really well. He's at the 2.5 level of care. He seems to be accelerating in his program.
Okay. That's a good report. Anything you want to say, Mr. Anderson, about that? Looks like there's some progress since the last report, then, it looks like.
Yeah, I can't think of nothing to say.
When do you want to come back, Mr. Stratton?
Your Honor, we could try the middle of May. Maybe
May
some-
15th, that's about as middle as you can get.
Yep, that's nice.
May 15th will be the next one.
May 15th. Okay.
10 o'clock.
Thank you, Eddie.
You're good?
State of Ohio versus Darrell Campbell, case number CRB 23106.
Your Honor, have you approached on this case?
Yes. All right, Mr. Campbell's doing very well. Sounds like things are going much better, so we're just going to continue to monitor things, come back in maybe 6 to 8 weeks.
Yeah, that'll work. I'll get this to you.
June the 9th?
June 9th, that'll work, Your Honor. June 9th, sounds good.
For pre-trial, 10 o'clock.
State of Ohio versus Christopher Casella, case number CRD 23114.
Your Honor, we have theft here. We'll plead guilty to it today.
All right, is that correct, Mr. Casella? You wish to enter a guilty plea?
Yeah.
Okay. Before I sentence you, I'd like for you to do a urine screen. If you go to the probation office and do a urine screen.
Yeah, I don't think there's a problem.
Mr. Cooper will show you where to go.
State of Ohio versus Austin Hensley, case number CRD 23117.
Mr. Stratton's case set for pre-trial.
Your Honor, I just asked this is our first pretrial on this. I just asked this be set for another pretrial. Maybe that May 8th date.
All right, defendant's request, case is continued to May the 8th for another pre-trial.
Now, Your Honor, in order for us to agree to move it out that far, we need a time
Time
limit.
waiver.
Yeah, I'll sign a time waiver. All right.
State of Ohio recalls Brandon M. Coe, case number CRD 22777.
Your Honor, this is a case where the victim in the case was okay with the 90-day dismissal on it. Mr. Coe is not able to pay the cost today. If we could set it maybe for Monday, we could pay. You could get costs paid and get it dismissed for Monday. Maybe not even appear.
So is the state agreeable with that?
Well, we're in agreement. I don't guess I saw it on the docket.
Well, he had missed a hearing allegedly on March 20th. It was on the docket then. He came today, so.
15, 16, 17.
Back in the middle of March, she said there's no problems.
Okay, we did have contact with the alleged victim back in the middle of March. That was the last time we spoke with her, but she said there had been no problems, so we haven't heard anything more, so we assume it's still okay.
Yeah.
So we don't oppose further time.
Well, he wants to, are you still willing to dismiss it? I guess that's what we need.
Yes, unless we hear that there have been problems between now
Want a
and
week then to ascertain that? 17th, is that enough time? Yes.
Philip.
All right.
Yes.
April 17th, if there's no further problems and the victim agrees and the costs are paid, it'll be dismissed without an appearance.
Okay. So he does not need to appear.
All right.
Okay. Yeah, if you pay it by then, you don't need to appear. Yep. Right. Come here. Yeah, come here. Okay. All right.
State of Ohio versus Ryan Mount, case numbers PRC 192270 A and B, PRC 202545 A, B, and C, case number PRD 202139 A and B.
Mr. Steyer's case.
Your Honor, since we were here last, Mr. Mount have you been arraigned, right? He's been arraigned in common pleas court on felony charge. I'm not representing him there, Mr. Meadows. Mr. Meadows? Yeah, Mr. Meadows is representing him there. That is going to be an ongoing case. I don't know what the sort of status of it is at this point. Obviously, we're just at the very beginning of it. Are you getting any kind of treatment at this point? Yes. Where are you?
Hometown.
Are you inpatient?
Yes.
And he is inpatient at hometown recovery.
Okay.
So we would ask, at this point, I mean, I'm not, he's obviously not going to be able to do much on the case right now. Maybe go out, maybe, 3 or 4 weeks and come back, regroup, see where we are on the other case, and maybe then at that point, he might be somewhere at hometown where we can figure out if he can start making some progress on these old cases.
Do you know when your next court date is in Common Pleas?
19th this month.
19th of April?
Yes, sir.
He's also on an ankle monitor.
May the 8th?
I have a jury trial that day, Your Honor. I don't know whether that's going to happen, and actually, that's the day we have that Porter case scheduled as well, so that may be an issue.
May 15th?
But the 15th, I'm available.
All right, Mr. Mount's cases are set for May 15th for pretrial. May 15th is the next hearing, 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Storm S. Pitts, case number TRC 222343, A, B, and C. Did not check in.
I think we had said that he could appear by video today, but I don't see him on the monitor either.
Storm S. Pitts.
I'm going to ask if we can have this case recalled a little bit later in the docket, and I'm going to attempt to contact Mr. Pitts.
All right, case will be recalled.
Thank you.
State of Ohio recalls Christopher Casella, case number CRV 23114.
Who said it was not good service?
All right. Have you seen the results?
I have not, Your Honor.
I won't wear any treatment.
I'll just ask for the typical sentence on this, Your Honor, what the court typically does.
Mr. Hill, anything?
Under the circumstances, Your Honor, our request would be a suspended jail sentence and some community service, probation, a small fine.
All right, I'll impose a $100 fine cost, 10 days in jail suspended to 5 days of community service, 2 years of probation, order to stay out of Walmart. And your review hearing is going to be November the 13th.
Okay.
If you finish everything before then, you don't have to appear. If you haven't finished it, you got to show up at 9 a.m. Explain why you couldn't finish it and ask for more time. You're going to meet with Mr. Major in the probation office to the left as you leave the courtroom. Check in with him on probation. After that, you're free to go.
All right, thanks. Just go back over there. Everything's good on that.
Purpose alone. Service pay the fine.
Yeah, as long as you do that, you don't have to.
Okay.
Yeah,
All right, thank you.
you're good. All right.
State of Ohio versus Jason Lindsay, case number CRV 22522. Jason Lindsay, did not check in.
I haven't been able to get through to him.
This is Mr. Thompson. Now, the thing is, on him, I got to text from Randy West, who's with Pathways. Says Jason Lindsay should be there this morning. He's doing good. He is compliant with everything. So,
Can we move this to next Monday?
at the finished request, I'll continue it to the 17th.
What is the gentleman's name at Pathways, Your Honor?
Randy West. I'll send you his contact information.
Thank you very much.
We'll ask for a time waiver too, Your Honor.
Okay, just sent it.
Thank you.
State of Ohio versus Heather Blevins, case number CRB 23-158, TRC 23-261A and B. And State of Ohio versus Courtney Riggs, case number CRB 22-738.
Your Honor, Heather Blevins, I believe, both of them are represented by Christine Scott.
Right.
The special prosecutor on this case did not have this case on his books today, I think, and Ms. Scott also had sent motions to continue. I know this morning it has, on the Blevins case, there was a motion to continue. There should have been another one coming on the Riggs case, but I asked both of them to be rescheduled.
Now, the one, Blevins is with you, Mr. Gill, is that correct?
Yes.
And the other one's with Ron Ashford. So on your case, you already have an entry continued to April 21st, which I'll approve. So that's 23-158, Heather Blevins. So I'll mark it continued to April 21st. Yes, that is a project. April 21st at 10 o'clock at defendant's request. Now,
On the Riggs case, Your Honor, neither party had, and the reason I called Ms. Scott this morning is because I knew that she had went to North Carolina this weekend, so I had called her to talk to her about her cases that were on the docket today, and I guess neither the special prosecutor nor her followed through with the motion to continue on this, but I just asked to
well,
get...
there actually was an order, and look, it's a type order, so I'm assuming one of them prepared it, and it's got, says it was, you know, not a, it's a facsimile signature by both, and it was ordered, that was March 29th to be sent today.
Oh.
Anyway, I had text with Mr. Ashworth, and he requested May the 8th, so I'm going to set it for May the 8th.
I will send her a text message about that, Your Honor.
And he said he would be in communication with her, so.
Yeah, I'll send her one also.
All right, May the 8th on Briggs is when it's set for, 10 o'clock.
And the 21st on the
On
other.
the other, yes, it's 21st.
State of Ohio versus Gretchen Smith, case number CRA 22393A and B, CRA 22502A and B, TRC 221661A and B. Mr. Steyer's case.
Do you have any money for cash with you? How much?
have this report from Sunrise Treatment Center, but it's not a facility I'm familiar with.
She's here, apparently. Someone from that agency's here.
Yes.
Does you have any questions?
Are you Miss Blevin?
No, I'm actually assisting her right now. I do the intake at Sunrise, but I'm transferring to the court part of it also. Gretchen, she's doing amazing. Like, she's thriving in every aspect of her recovery right now. Like, she's building relationships back with her kids. She's got a full-time job, assistant manager. Like, she's really thriving right now.
Thank you.
You're welcome.
What was your name, ma'am?
My name's Angie Cottle.
What's your position here?
I do intake coordinator,
What's the address?
1907 11th Street, Portsmouth.
Portsmouth?
Yes, sir.
Well, what I'd like to see is a urine screen here. I mean, I know they say they're doing it, and not that I don't trust them, but I don't have any other results other than they just say they're doing it. So let's order one here, see what the results are.
Okay, I can get those sent to you.
No, she's gonna go ahead and, they're gonna
Oh,
have
he
her
here?
do
Okay,
one now.
sorry.
She's gonna
Yeah,
do
that's
one
fine,
for the
sorry.
court here at the court. So
Thank you.
just go to the probation
you.
office
Okay.
and do a urine screen, and I'll have you back out.
State of Ohio versus Daniel J. Markins. Case number CRA 22-813, CRA 22-811.
Mr. Thompson's case. Is it Bethesda?
Your Honor, I've spoken with Brittany Markins, and she says that their contact is limited to exchanges of their child and things of that nature, and she says they haven't had any problems. The last time we were here, there was a discussion about the fact that Mr. Markins's report from Bethesda was not entirely good and that he needed a better effort, and we discussed transportation issues and things of that nature. So, I guess we've got a new report today, unless this fell out of my, no, this is for today.
It does appear to be better.
Yes, so we're very much encouraged by that. So we don't have a problem with continuing this on for the purpose of having Mr. Markins follow through to completion of the program.
We're good to continue on. I think this has been going on a while, so.
Since December. So is there any projected finish date or?
I could pull up his file and see.
Let's come back in a couple of months and we may look at concluding it then.
Okay, thank you.
In June, what's best?
Any Mondays?
Mondays or Fridays?
Any Mondays, sure.
June 12th?
That'll work.
June 12th will be the next hearing.
Thank you.
You're welcome.
We'll get it done.
State of Ohio versus Alyssa R. Sowers, case number CRA 2158, CRA 2460.
Okay, I remember seeing it. Okay, thank you so much.
Your Honor, we should have a report from OVP.
No, sorry, I'm pregnant.
Is anyone covering for J.T. Holt today? Corey, he is Corey Little.
Your Honor, I guess I am on that. Mr. Holt contacted me this weekend, said he wasn't sure he was going to be, didn't think he was going to be able to be here today, and I've spoken to Mr. Little, sorry, and he and I have an appointment this afternoon. He had discussed retaining me anyway, so we've got an appointment set this afternoon. So
He's out of jail now.
yeah, he's here, so we were just going to basically, I mean, I guess I'm not on the case yet, so I'm going to instruct him to ask for a continuance.
All right, who was the other one?
Willie Linville.
Linville? Is there a Linville?
Another case.
Okay. Because he's on the docket. I know he had sent me a text that he was in another hearing today.
And then I believe Kayla Schrader was on for today as well?
Is that J.T. Holt's case?
Yes. Okay. I'll look and see, maybe it's been moved already.
Linville's out.
I checked this morning.
All right, is Ms. Sowers still at OVP?
Yeah. They should have sent a paper, a fax in a paper this morning. She said she was gonna put it in my file for me.
I see where you signed there's a authorization for release of records, but I don't see anything from you.
That's like the fourth time I've had problems with them. I even had to go there before I came here this morning to sign more papers. Yeah, no matter what, I don't care.
Your Honor, could we move this out a week and we'll make sure that she has the paperwork?
Okay. The 17th?
Yes, sir.
She's at OVP now, is that right?
Yes. April 17th.
Seems like we always have problems with getting paperwork.
Well, recently, I mean, before Brianna DeMint was here and was pretty good about getting us what we needed. Now, I don't know if she's getting
She's pregnant.
close to
Yeah.
delivering her child.
Yeah.
She's not here, and we're not getting the paperwork we need.
Okay.
I have an email tonight too.
Okay, and then I'll have a copy myself. Text me your email.
Okay.
You want my number, right? Okay. Thank you, Judge Capper.
You're welcome.
State of Ohio versus Philip Bailey, case number TRC 23206 A and B.
Is that the last one?
I don't know if that's your birthday.
I have
driver's papers. Should I be getting something else pretty soon? Or something has for me? How long is it? It's almost a month now.
Mr. Morford's case, 23206, Philip Bailey.
Do you want to come in and watch some video?
I don't have any meetings in that time.
I think you ought to.
Okay.
Before you, unless you want to just go ahead and.
I just want to go ahead and get it over with.
You want to plead guilty? Is that what you're saying?
Well, no, yeah. When they don't want to video, if that's what you want to do.
Judge, I'd like to ask you for a short continuance. I think he's a little confused right now and has not had an opportunity to come in and watch the video of the stop. So if you don't mind, I'd like to have a couple of weeks to get with him.
May 1st, yeah, May 1st.
That's good here, Judge.
Is that the finished request?
Call him. Okay.
Thank you, Your Honor.
State of Ohio versus Cameron Harless, case number TRC 2348, A, B, and C. Cameron Harless.
Cameron, all set for briefing.
It's going to be the same request, Judge. He wants to come in and watch the video. I provided him a copy of the written discovery response, but he wants to watch the video.
May 1st?
Yes, please. Thank you, Your Honor.
You're welcome.
Thank you. State of Ohio versus Joseph O'Malley, case number TRC 23103, A, B, and C. Not checking in, Your Honor.
I'm hoping he's going to be on Blue Jeans.
Not yet. Ryan Jeffers.
Joseph O'Malley, been called for, has not appeared. Do you want to recall it later in the docket, or?
Please, I'm going to try to call him, Judge.
Case will be recalled.
State of Ohio versus Ryan Jeffers, case number CRB 23103, A, B, C, and D.
Mr. Jeffers is on teleconference. This is Mr. Morford's case.
Mr. Jeffers, the state has made an offer to you to plead to criminal damaging and the disorderly conduct. And they will leave the fine and to the discretion of the court. The state would also ask that you do 5 days of community service. Is that something you want to take advantage of? Do you want me to call you and talk private? How do you want to?
Yeah. Could you call me?
Do you have a telephone number there?
Yes.
Can I have it?
71442-2834.
Judge, if you don't mind, could we recall?
This case will be recalled later in the docket.
State of Ohio versus Kyle Sias, case number CRD 22794.
Kyle Sias is
Did not check in.
Mr. Morford's case, and he had failed to appear on the last hearing date, March 27th, and I agreed to continue it today, but my notes were he did not show today, would issue a warrant.
Your Honor, we have information that, from, is that his mother? From his mother, that he's in a psychiatric hospital in Columbus, and she did not expect for him to be released by today, so.
Well, how do you want to handle this? Do you want to keep the case pending? Do you want to null it? How do you want to go forward?
Do we have a protection order? Yes. Well, one of the factors that we would look at is whether there was a protection order in place.
I don't think there was.
And there is not. So it's an M4 domestic violence. And of course, the alleged victim is his mother, who...
It looked like she wanted him to get help was what the issue was.
Yes, and he's getting help, and it's not a physical altercation. It was a threat made at an earlier time, so we will go ahead and nullify the charge. If she comes forward and insists that we shouldn't have, then we would request the right to refile.
Case will be nullified.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Trevor Hodge, case number CRA 2378 and CRA 2379.
Mr. Tyler Smith's case for preliminary hearing.
I'll take that. It's awesome.
You don't have a, they didn't give you. I sent they made me sign a release of information, I sent them an email. Okay. And everything. All right.
He's treating a PROACT, Your Honor. He signed a release to have the report sent here. And I just asked Mr. Cooper
I don't have anything.
if we had anything PROACT, and it doesn't look like we do.
I mean, I have to sign a waiver. I mean, I have to
Do
do
you have a West Virginia medical permit?
I have Cigna.
Cigna?
He has health insurance?
Yes.
And they're accepting that?
Yeah, I've been going. They made me sign a release of information so they could send you an email. I just don't think they did then.
Yeah, I don't have anything. Let me try. I think I did it the last time. I sent my contact there. Something. Well, without a report, why don't we have him submit to urine screen? Come back.
State of Ohio versus Shandon Pringle, case number CRA 22563, CRB 22564, CRB 2189, CRB 22295.
This is Mr. Smith's case. Yeah, report.
I'm sorry, Ron, I didn't realize.
They were discussing, how do we want to proceed?
Well, I don't know whether you can characterize the report as any better or not. She hasn't been kicked out. But for some reason, they feel like she's not putting forth any effort and not listening to the rules and the advice and all that kind of stuff. I don't know if she's making any progress at all. I was just looking at the history of the files and what we have that we may need to just try to go forward on at this point. We prefer her to get with the program. I have felt for a long time that this is a young lady that has a great amount of potential, but it looks to me like she finds ways to defeat herself. And there are limits to what the counseling agencies can do for a person. And, you know, maybe jail is what it takes. Maybe prison's what it takes. I don't know. But I would suggest that if there's not a markedly better report next time, that we're just going to have to take a different path.
Your Honor, I was asking about the report. That's what we're discussing to get a better understanding. I believe the behavioral contract she's under expires today. It's a 2-week behavioral contract. There hasn't been incidents in the 2 weeks. I believe the reason she's put on that is because her uncle died and she wasn't allowed to go to the funeral, and that's what she was upset about. And she understands that she's going to have to. Yeah, I think you've had anger management before when you were with Spectrum. And
that's what I wanted to ask, if they were sent into the court.
Okay, so there's some issues she still has to work with under this thing. And as far as the sleeping and getting up, I guess the doctor had her on 3 different sleeping medicines, but they've regulated now, and it seems like that's getting better. So some of these things should be improved. Hopefully the next report is a glowing report. They do have her marked as progressing, but have her marked as non-compliant based on the summary for progress. So, yeah, I'd like to see her to continue in this court and continue with her treatment if possible. I know that she's at the point where your son is going to be returned to you in the near future.
That's what I wanted to ask about, may I speak?
Yes, ma'am.
Okay. When I first came from Spectrum, I was asked to do 84 more days. So what I'm asking to do is if I can do the 90 days, like instead of the 84, do 90 days in residential and then do 3 months in sober living so I can work on getting my son back. Because that process is all in Fayette County in Lexington, Kentucky. That's something I'm really trying to work hard for right now.
Do you have a hearing date there, or who has custody of your child?
My mom, but I was eventually able to speak with my son's attorney. The case is now closed. I've gotten my parenting certificate done. They wanted me to have some clean and sober time and me do a program. So, and that's why I wanted to ask, because I know it was 84 days.
Your mom is living here?
She's in Lexington.
She's in Lexington.
But there's certain things that I have to get in order before I take steps in the court there.
Well, one of the things you haven't finished the program yet, and you have a felony pending. Here's the problem, as I said, you've never finished. You've had problems at every program you've been at. So sometimes I could see, there's a personality conflict. But when you have a problem at every place you go to, that tells me there's a problem that you need to adjust. And here's the other thing you need to realize. You've got a felony. Which means you're only here by the grace of God in this court. And if the state gets worn out with you and say, we're giving up on her going to being successful in treatment, they could just take it to the grand jury, indict you, and you're going to be in the common police court where you've got a chance of going to prison or to STAR. Prison, I think we all know what that means. STAR is much more confining than where you are now. It's a lockdown facility. You cannot leave. And you're watched 24/7. I don't think any of those are good options. What I would want to see from you, getting your son back, that's a great goal. If you heard what I told, you need to do that. This has to come first. Your sobriety has to come first now. And in a way, that's putting your son first. Your son, I assume, is in a safe place with your mother. You're not being compliant with this treatment, and there's still this risk hanging out there that you're going to go to prison because you're not doing what you're supposed to. Does that enter your brain at all? You're just standing up there and saying, well, this is what I want. I want to do this. And everybody else is saying, you're not doing what you're supposed to do to get clean. I just don't understand the thinking, because if it was me, one, I wouldn't want to go to prison, because that means it's longer that you're going to be without your son. It's going to be terrible. It's not going to help you. But I don't see any fear on your part of that. I don't see any recognition that that's a possibility. I don't see that in your motivation. I like positive motivation, but sometimes negative motivation can be good too, because I have a fear of what's out there that's going to be terrible. I don't see you recognize that at all. It's just like, I want what I want, and if you people don't give it to me, I'm going to throw some kind of fit. And if that happens, I say all the time, this is a court for people that want to get clean. Because I've got too many, you sit here and watched it, I got too many people, I can't force you to get clean. I can give you the opportunity to get clean, but you got to take it. Ultimately, it's got to be you. You've got to adopt it, because you're in a facility where you're not locked down, you can walk away at any time. If you need that to be locked down, go on down to the common police court and deal with a different judge. And try telling them, Judge, this is what I want to do. I want to go to Lexington, I got my kid I want to get, and, you know, you get on my program and see how that works for you. What I don't see in you, Ms. Pringle, is committing to being clean is the number one thing. That has to be the number one thing in your life right now. Then you can get your kid back. You haven't convinced anybody yet that you're going to be clean. I'm going to go out on a limb and say that judge down in Lexington is not going to be convinced once they see the reports you've been getting up here. You got to get some good reports. Not that you won't get out of bed when you're asked to. No, you've got an excuse, you know, your meds or whatever. Maybe that's correct. But you've got to get these excuses out of the way. You got to make this work. People don't want to hear excuses. They want performance. Because if I'm the judge, if I was sitting in Lexington and I had your child welfare in my control as that judge, I want that child to be in a place that's safe, where there's nobody using in the household. And I don't know as the judge that I would be convinced of that. If right now I wouldn't be. So you got work to do. Do you want to stay in this court?
Yes, sir.
Do you want to be successful?
I do.
Well, show me, because you haven't, where you were at Spectrum, and then where'd you go after that? Then now you're at Bethesda. And this is not a great report. You need to be getting great reports to make what you want to happen, happen. Get me some great reports, and then I'll say, I'm convinced. Go talk to that judge down there. You take this report to the judge in Lexington, I don't think is going to be too impressed. Do you? I mean, really? Do you think they're going to be impressed?
Not with this one, no, I do not.
No, they're not. So let's get, in reality, you're going to have to get clean and convince everybody, including the judge in Lexington, that you're clean. You haven't done that yet. And when I mean clean, I mean that you're going to be clean when you're out on your own with your son. That you're going to make him top priority. And that means staying clean. Whatever it takes to stay clean, you got to do it.
Yes, sir.
You want to try another month, Mr. Gill? Because eventually, if you keep getting these kind of reports, I think they're just going to take it to the grand jury, get you indicted, and you'll appear in front of one of the common police judges, and whatever they decide, that's what you're going to do.
Your Honor, I made a note here in my file that things got to be better next time, or we'll take the misdemeanors and ask for those to be set for trial here, and we'll send the felony charge to the grand jury, so she could potentially go to jail here and go to the grand jury. So we don't want that to happen, but we will.
What do you want to do?
I'm going to have a good report.
Okay. We'll try another month and come back with a good report.
Okay.
May 15th?
That's fine, Your Honor.
May 15th will be the next hearing.
Thank you.
You're welcome.
Bateman, Bowling, Freeman, Freeman.
State of Ohio versus Willie Linville, case number CRA 23157, CRB 16350, CRB 14674. And also the State of Ohio versus Corey Little, case number CRB 23218, AMD, CRA 23216. CRB 23194, AMD, CRB 23195.
All right, and Mr. Steyer is standing in for Mr. Holt, who's in another court.
Regarding
both these cases.
Regarding Mr. Linville, he is in treatment with Bethesda. We've got it. Do you have a copy for the judge?
Yes.
We have a report here from him showing compliance and progress.
Okay, sounds like there's still work to be done.
Right, it appears he's pretty fresh into the process, so my thought at this time would be that the court would likely wish to continue this on anyway. I don't know if you have any dates that Mr. Holt is available, or just want to pick a date far enough out that if there's an issue, he can.
One thing I am confused on is that the judgment entry of March 20th, 23 says you got an OR bond released to Bethesda for inpatient treatment with an ankle monitor.
Yes, sir.
He is.
Oh, he is inpatient,
Yes.
okay.
It does say outpatient.
It says outpatient.
It says 2.5 though, which I think is
That's the level of care.
inpatient. No, is the number you usually see for inpatient. I think that may be a typo, Your Honor.
Okay, so he is inpatient?
Yes, sir.
All right, thank you. So I'm changing that on the report. Okay, very good.
In that case, then, Your Honor, we would just ask for another court date. Like I said, if you have notice of when Mr. Holt's available, work around that. If not, you can just set it and he can.
I don't.
Then I'll let him know the new date then, and he can file for continuance if there's an issue.
May 1st.
Thank you, Your Honor.
Thank you.
Appreciate the chance.
Thank you for taking advantage of it.
Yes, sir.
May 1st will be the next hearing.
Yes, sir. Appreciate it.
Thank you.
You're welcome. All right, and Corey Little.
And Your Honor, Mr. Little had contacted me this weekend about the possibility of retaining me on this matter, so he has not retained me at this time, but Mr. Holt did ask me to stand in with him. I don't think there's any conflict with me going ahead and standing in and saying, we'd like to request a continuance so that I can meet with Mr. Little. I will be here, I can't be here next Monday, but I can be here the following Monday. That should give Mr. Little time to get me retained if he wishes to, and if not, Mr. Holt can determine what needs to be done from there.
What date did you say?
I was going to say the 24th if that day works, but I believe it's your discretion. And so I kind of remembering you said those days were getting heavy.
Mr. Hill?
Okay, we're not opposed to a short continuance. Now, we are, even though Mr. Little is now in treatment with GPS, is that what's happening?
Are you on a GPS monitor?
They took me to, I posted another bond.
He's posted bond.
Okay, all right, well, we'll need a time waiver. We're also going to need to start thinking about setting these for trial if we're not going to have some other proposal as to a way of resolving these.
Again, I think the 24th seems like a good time frame if I'm going to take the case over, and if not, to give Mr. Holt time to figure out what's going to happen.
At the defendant's request, all cases before the court for Mr. Little are set for April 24th.
$10.
And are you going to let Mr. Holt know that?
I'll let Mr. Holt know the new dates. Thank you.
You're welcome.
And then I think Ms. Smith has been tested as well. You're done.
State of Ohio recalls Gretchen Smith, case number CRA 22393A and B, CRA 22502A and B, and TRC 221661A and B.
That's a good test.
Thank you.
Congratulations.
Thank you, Your Honor.
All right, we'll continue on then. You're continuing at Sunrise. Couple months?
That would put us
Mid-June.
June 12th would be a good day, Your Honor.
Yes.
Can I am?
June 12th will be the next hearing.
Thank you, Your Honor.
You're welcome.
I'm gonna stop and pay on some of my fines when I leave.
Wonderful.
Thank you.
Thank you.
State of Ohio recalls Trevor Hodge, case number CRA 2378, CRA 2379.
And I do have a report from proactive.
Oh, you did? I just got the front. Okay.
It says he is compliant. He was supposed to have a report written 2 weeks ago, but his therapist has quit, so he didn't get a report. He tested positive for alcohol and THC, so that's not great. We'll pass that along to the clerk. Are you paying any of your fines today?
No, sir, I'm currently unemployed.
Okay, you do community service.
Your Honor, he has been here
Okay,
for community service.
all right. Continue at ProAct. I sent your report along to them. Let's come back for his next hearing in May. May 22nd? Is that good, Mr. Smith?
Yes, Your Honor.
May 22nd will be the next hearing. Preliminary hearing and pre-trial.
That's it.
State of Ohio versus Kara Hearn, case number CRB 2381.
This is on the sentencing docket. It's my understanding she's at ODP now, or?
Yes, Mayor Bruce.
Yes.
It's a good letter, Your Honor. She's been attending everything, really, right? She's been doing well.
So this is, you're in the inpatient program. So she can't do trial.
She can do, once she gets out, they'll reassign her to me. She's just on temporary suspension with me.
Okay.
I just felt that I needed more intense
I
treatment.
agree.
More accountability, Your Honor, is what she felt like she needed, so.
She's set to graduate here May 5th. Why don't we come back that day?
Okay.
Your next hearing date. That's a court date, May 5th. For sentencing. 10 o'clock.
Thank you.
Thank you.
State of Ohio recalls Storm Pitts, case number TRC 22, 23, 43, A, B, and C.
Mr. Stiers' case, we're going to try to contact Storm.
I tried and I've had no response. If he contacts me, I'll tell him that he has a week to appear before warrant issues.
The warrant issued in 7 days.
Thank you.
State of Ohio versus Eric Chapa, case number CRA 23-136. Check the bond forfeiture.
All right, this is the bond forfeiture. Thanks, Mr. Sowers. Okay, I'm going to continue this chapter. I know this is the one that was supposed to turn himself in Louisiana. And I don't know if he has done that. Mr. Sowers is out of the country, I believe. So let's continue to the 24th for another bond forfeiture.
State of Ohio recall Stephen T. Wells, case number TRC 22-2615, A, B, and C.
Phelan Bowley and Brandon Freeman.
Well, it's still not named, so let's hold up on that one.
Sorry. I'll go get him in case Mr. Wolford's case gets worked out.
Yeah, he's called. It's not
Okay, we have stuff to do. Okay, let's go ahead and do the things we have at the jail.
State of Ohio versus Joshua M. Hay at the Lawrence County Jail, case number CRA 23-213, CRD 21-324. Richard Wright is on deck.
All right, Mr. Hay is at the jail. Can you hear me, Mr. Hay?
Yes, sir.
Have you retained an attorney?
Recording has started. Yes, sir, I have.
Who's your attorney?
J.T. Holt.
Okay, well, he's not here today. Have you talked to him recently?
My mom was able to get decent trial today or something.
Okay. Yeah, we can schedule it for Friday. Well, I guess we'll have to do. Have you had any conversations with Mr. Holt?
I have not, Your Honor.
It's my understanding that you, because I set your bond conditions, but it's my understanding you now have a holder from the parole authority?
No, I have no holder right now.
Okay. Are you going to attempt to post bond?
I was going to respond to they never come to any longer, so
Okay. My conditions of bond were 5,000 cash or surety with an ankle monitor and get substance use treatment and assessment. So that will still remain in effect. It was my understanding that that was negated by a parole authority holder, but you don't think that's in effect now? Is that correct? Mr. Hay?
Your Honor, that's what the adult probation and common police told me, that there was a APA holder. That's why they didn't place the ankle monitor.
Okay.
I haven't heard anything today, Your Honor.
Okay, well, we'll check back. If that's correct, then adult probation can place an ankle monitor once you post the bond. And I'll reschedule your case for a hearing for this Friday. This is the 14th. April the 14th is your next hearing. You're welcome.
State of Ohio versus Richard Wright, case number CRV 19218, CRA 181347, CRV 181348. Barry Vaughn is on deck.
All right, sir, you're Richard Wright. And this is for arraignment, it looks like. Mr. Wright, you have a warrant outstanding for failure to appear at a review hearing on October 31st of last year, and that was on a disorderly conduct and a drug abuse instrument charges. You have a right to remain silent. You don't have to say anything. If you choose to make statements, they can be used against you. You have a right to an attorney, have one appointed if you can't afford one, and to have bond. So let me ask you, do you admit or deny you missed your review hearings? Do you have a good explanation for not coming? How long you been in jail?
4.5 months.
Oh, well, hopefully you haven't been in our jail 4.5 months. What jails have you been in?
I've been to the gun.
Okay, so they transferred you from Boyd County directly to our jail?
Yes, sir.
Do you have a charge in common pleas court also then?
Yes, sir.
You think these are the only things you have?
Your Honor, I'm really not sure. I'm trying to find out since I've been here.
Okay. Where are you living now? Well, once you get out, I guess I should say. Once you get out of jail, where will you be living?
My safe place.
In Ironton?
Right.
Okay, so you are going to live in Ohio. Well, I suspect you got something in common pleas court where they wouldn't have transferred you from Boyd County to our jail. But just in case, here's what I'm going to do. Because you owe community service and fines, all you have in my court, and they're misdemeanors. So I'll send you to time served for contempt for not coming to court, and I'm going to give you a new review hearing date. And so I'm not going to hold you anymore. If this is all you got, you're going to get out of jail. Now, if you got something across the street in common pleas, you'll have to go over there and deal with them too. You understand?
Yes, sir.
Okay, to make this easy to remember, I'm going to set your next hearing in my court May 1st at 9 a.m. So if you get out of jail, you got to get to my court May 1st for another review hearing and start working on what you owe, which is community service and fines. Of course, if you don't get out of jail because common pleas has a holder on you, then I'll see you just like this again on May 1st by teleconference. And you can tell me, I've been sitting here the whole time because common pleas has a holder on me. Yeah. Go ahead. Yes, sir. You can work your fines off too. You get $50 a day for each day you do, except on April 29th and May 6th, we're giving double credits because it's a township cleanup day. We want to help them get more people out. You'll get $100 credit for working that day. So come out and work those 2 days, and that's $200 off your fines right there in 2 days. Any other questions? April 29th, May 6th, those are the dates, and you can check with the court if you can't remember them. All right, May 1st is your next hearing. Well, May 1st is before the May 6th date anyway, so April 29th would be the one that's going to be in play. You can get 2 days credit for 1 day then. All right, that's all.
State of Ohio versus Barry E. Vaughn, case number CRV 21540, PRC 201678. Tanner Howard is on deck.
And sir, you're Barry Vaughn. Mr. Vaughn, it's alleged that you missed a review hearing on October 7th, had a warrant issued October 14th, and it looks like you got arrested here recently and been in jail on this warrant. And the warrant was on 21-540, an attempted possession charge, and looks like an OBI. Yeah, OBI charge, 20-1678.
You know, supposed to go to outpatient. I finished rehab successfully. I was supposed to go to outpatient. My wife's just feeling sick, and I didn't go to my outpatient for that. But I mean, I would be glad to do it.
Well, it doesn't look like you did any. You paid $100. I'm showing, that's all I'm showing that you did. You paid $100. That went towards your fines. And
How much do I owe?
well, looks like a lot. $1,150. It looks like between the two cases.
Okay, I didn't know.
And you got community service to do too. You had 5 days of community service. I'm not showing you did any of that either.
Okay, I can take care of that too. You want to go start?
How long you been in jail? When did you get arrested? Are you still still living in Ironton?
Yes, Your Honor. Yeah.
Okay. I'll send you to time served for contempt. Set your next hearing for May 1st.
Thank you, Your Honor.
You gotta get this community service done, and April 29th, you can get 2 days credit for 1 day.
Yes, sir.
7:30 a.m. here at the court.
Yes, sir.
Okay, that's all.
State of Ohio versus Tanner V. Howard, case number CRV 21427, and Melissa Snell's on deck.
This is Mr. Tyler Smith's case for sentencing.
Yes, Your Honor. I believe March 29th in Common Police Court in Judge Finley's courtroom, Mr. Howard was sentenced to 4 years in prison, but an opportunity to get a judicial release after 6 months. So if the court's agreeable and the state, if we just run any sentence concurrent with that.
Mr. Field? It's domestic violence, so this is the charge.
And he's proposing that he would resolve this today by entering a guilty plea.
He's already pled this for sentencing.
Oh, okay. Yeah, we don't oppose the sentence, whatever the court imposes, running concurrently with whatever he's going to get in common pleas court.
Anything you want to say, Mr. Howard?
Well, I thought I was doing the right thing, but I turned myself in, he started it, 2 years ago, I'm losing my family because of it, but it is what it is.
Well, but you're going to prison over something unrelated to this, right?
Yes.
Yeah.
Okay.
I guess so. It's all right, though.
He's already pled to this charge, Your Honor, so
Yeah.
it basically it's just sentencing. So he's been in since March 29th in the county jail. He's just waiting for transport.
All right, on the domestic violence, I'll impose a $100 fine, court costs, 30 days in jail, and it's been in since March 29.
Yes, Your Honor, that's when he was sentenced and taken into custody.
I'll give him credit for 12 days. I'll run his remaining time concurrent with what he's getting from prison. I won't set a review hearing since he's going to be, he will be in prison for a period of time. It will enhance, if you get another domestic violence, it's going to enhance it, so.
Yeah, you ain't got to worry about that.
This is not filed.
Okay.
This is not filed.
That's all.
All right, thank you, Your Honor.
Thank you.
You're welcome.
State of Ohio versus Melissa Snell, case number CRA 23224, A and B.
Melissa Snell is for arraignment. Okay, I'm Melissa Snell. Ma'am, you're Melissa Snell? I'm Judge Capper at Orange County Municipal Court, and this is your arraignment. You have a right to remain silent. You don't have to make statements. If you choose to make statements, what you say is on the record, it can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove any charge beyond a reasonable doubt. Okay, I'm going to go over the charges with you. Did you understand your rights that you have, Ms. Snell?
Yes.
The charge alleges possession of drugs. Then on April the 7th of this year, you knowingly obtained, possessed, or used methamphetamine, a Schedule II substance. That's a felony of the 5th degree, maximum penalty, 1 year in jail, $2,500 fine. Do you understand that charge?
I think so.
Then you've got another possession of drug charge, which is the B case, and it alleges that you knowingly were in possession of fentanyl at the same time and place. Also, 5th degree felony, maximum penalty, a year in jail, $2,500 fine. You understand that charge?
Yes.
You have the money to hire a lawyer.
No.
You have a job.
Yes.
Where do you work?
I work at Walmart.
Are you paid by the hour?
Yes.
How much per hour?
$7.50.
Okay, you're eligible for a court-appointed attorney. I thought the minimum wage was higher than that now. Oh, here we go. Mr. Morford.
Your Honor.
I'll appoint you.
Thank you, Judge.
You're welcome. Mr. Morford's going to be your lawyer, ma'am, and he's here in the courtroom. I'm entering a not guilty plea for you. Well, these are felonies, so really don't need a plea. And where do you live, Ms. Snell? In Chesapeake?
Yes.
It says Riverside Drive, so that's not too far from the court.
Right.
State recommending assessment and treatment?
We would ask for that, Your Honor, yes.
Well, here's the way this would work, ma'am. I'll let you out on your signature if you'll agree to go get an assessment for some treatment. Would you agree to do that?
Yes. Yes, I will.
Have you ever been to treatment before?
Yes.
Where'd you go?
I went to a place over in Columbus.
Okay. What about locally? Have you been to any place locally?
No.
And Riverside's in Chesapeake, right?
Yes, sir.
I'm going to send you to Riverside because you can walk there.
Okay.
On Riverside Drive, right?
So,
Yeah.
you know where they're
I went to group meetings there.
at Riverside?
Yes.
Okay. Well, I want you to go get an assessment and treatment as soon as possible. I'm going to let you out on your signature.
Thank you very much.
I'll make it a $2,000 signature bond. Do you have a cell number or a landline number where you can be reached?
I don't know my cell phone number. It's locked every month. This is, probably, it's a new phone number.
Do you have any way to get in touch with you?
Yes.
What? You got another number that you know?
That's the only number I have, that they have it down here.
At the jail they do?
Yeah, I thought,
When you get released, give me a call, and we'll sit down and talk.
Call Mr. Morford's office. He has an office in Ironton, so if you look that up, you should be able to get and maybe there at the jail they've got his number they could give to you.
I don't think they do. I get enough calls from them.
Okay?
I'm sure they've got it.
And then we need to, I want you to go, you know where the court is in Chesapeake, right? Yes?
yes.
Okay, you gotta be here for a hearing, and let's see when we're gonna set that. could do 2 weeks from today, is that good? Mr. Morford, you have
a trial then, Judge.
Well, let's do 1 week. Mr. Morford's tied up in trial on the 24th, so I want to see you in a week, the 17th. 1 week from today, next Monday. And I want you to get to Riverside and get started with your treatment before then.
Hey, Butch.
Okay, do you have any questions, Ms. Snell? Okay, we'll see you in a week. Yeah, that finishes up at the jail.
State of Ohio recalls Ryan Jeffers, case number CRB 23103, A, B, C, and D.
Ryan Jeffers is appearing by teleconference, and Mr. Warford is his attorney, is in the courtroom.
Your Honor, we're going to have to change the plea to 2 of the charges, and I believe the other one deals with knowledge. In consideration of the joint sentencing arrangement, Judge,
As we've got, this is 23-103, A, B, C, and D, I believe.
And Your Honor, I'd like, on behalf of the state, to explain to the court what we intend here. These charges were originally filed as, there's at least one felony charge, if the court will remember. It's been some time ago. And on the day that we were in court for a preliminary hearing, there was an inability for us to come to an agreement that would keep the court here, keep the cases here. So we nollied or waived, I think we nollied the cases to the grand jury. But it was always our intention to take time to reassess with Mr. Morford and Mr. Jeffers how we really wanted to handle this. I've been in communication with Mr. Graham, the principal at the school, throughout the process, and he has approved what we are proposing today. We feel that the entire situation is best characterized by a criminal damaging charge and a disorderly conduct of the misdemeanor of the 4th degree. The criminal damaging charge actually resulted in no monetary loss to the school. It was a door to the gym, I believe, that was slammed and broken, but it was repaired without needing any cost. So that, our request is that if he pled guilty to those 2 charges, criminal damaging and disorderly conduct, we would dismiss the other charges.
And what's the recommended sentence? Is there a recommended sentence?
10 days in jail, suspended, and did we talk about community service? 5 days of community service. Now, Mr. Jeffers also completed his hours needed, his classes needed in order to graduate, and so he is, he already knows that he's not welcome at either the South Point High School or Collins Career Center where he was actually attending school.
that's not going to be a problem, Judge. Number one, he understands the problems he might get into going around there. And secondly, he's just started a new job. I believe he's probably appearing from a riverboat this morning.
Okay, so it's my understanding that he is going to be allowed to graduate. He just will not walk at the graduation. He'll get a diploma mailed to him, but he will not attend any ceremonies.
That's correct, Judge.
Okay, do you understand that, Mr. Jeffers?
Yes, Judge.
Is there any, you have a right to make a statement if you want to before I sentence you. Do you have anything you want to say?
No, sir.
And you agree with what Mr. Morford has represented to the court, that you want to change your plea as he has instructed the court?
There's no jail time, right?
There's not any jail time being recommended.
We asked for 10 days suspended.
Suspended jail time is what was recommended to the court.
So I'm not in jail?
Well, I didn't say that. It's not up to you, and it's not up to the prosecutor. They can make a recommendation, but ultimately it's up to me what I decide to sentence you to.
Okay, but, yes, I will like to report if you want to.
All right, is there anything else you want to say or have questions about?
The community service, do I have to get reported?
Yes, you do. You're welcome. Okay, I'll accept a plea to the criminal damaging and disorderly conduct, so that's 103C and 103D. 103A and B are dismissed. On 103C, I'll impose a $100 fine for court costs, 10 days in jail suspended. Is restrained from going about South Point High School and Collins Career Center. He is ordered to perform 30 hours of community service, and you can do that at the court's community service program on your days off. We'll work with you on your work schedule. You'll have a review hearing on November the 13th of 23. You should have it well finished before then. If you do, you don't have to show up for the hearing, but if you haven't got it finished, you got to show up, explain why you couldn't get it done. And that'll be at 9 a.m. on November the 13th. On the disorderly conduct, I'll impose a $50 fine. No court costs. Probation will be level 5, non-reported probation. You can get a copy of your judgment entry from the probation office, or you can go online and look at your case and see what you're ordered to do there. Any questions, sir?
Did you say I have a...
Yes. Until you finish. Your probation will conclude once you finish what you're ordered to do. You're welcome.
Thank you, John.
What is that level 5 probation?
Yeah, I just think a level 5.
State of Ohio recalls Joseph O'Malley, case number TRC 23-103, A, B, and C. Joseph O'Malley.
Joseph O'Malley is on the teleconference. Mr. Morgan's his lawyer, and he's here. This is set for a pretrial today. Okay, Mr. O'Malley, are you there? I see something on the screen saying Joseph O'Malley, but I don't see anybody and don't have any audio. Have you had any conversations with him?
Yes, sir.
Okay, there's somebody coming online now.
I've called him. He's also texted me while I was sitting here in the courtroom, Your Honor.
Is it working now?
Okay, now, yes, it is.
All right, sorry about that.
All right, this is set for a pretrial today. How do you want to proceed?
Mr. Hill has given us an offer. You want to state the terms of the officer?
Your Honor, this is a first offense, and except for the refusal, there's nothing aggravated about it. I guess there's driving in marked lanes, we don't consider to be too serious on its own, even though it was part of the reason for the stop. Since he's admitted guilt, we don't have any problem with treating this with the minimums that the court can impose. We don't have a, he lives in Michigan, I guess, so we don't have a problem with him going to the school in northern Ohio someplace if that makes it easier for him.
He lives in Imlay, I believe, city, Michigan. At least that's where I got the repair bill for the car. Sir, did you hear Mr. Hill's offer?
Yeah, what is the, take a class and use that in Ohio, is that what it was?
In Ohio, or if there's one that's similar in Michigan, the court will
It
probably...
has to be approved by Ohio, though. and I don't know that there's any out of state that are.
I'll stand corrected and tell you, you probably ought to look in Ohio.
How far are you from Toledo?
About an hour and a half. I can make the trip if I have to.
Well, here's what the law in Ohio is, and I either have to make you go to this program or I gotta give you jail time. So I think you'd rather do the 3-day program. And it's not just a class, it's 3 days inpatient, which means you gotta go stay for 3 days.
Okay, I'll make it happen. I'll make sure I go.
There's lots of approved programs in the state of Ohio, just about, well, I'm sure the big cities have multiple programs. You know, the smaller, like this county's smaller, it has one program that's approved by the state. A county like Lucas County is gonna have multiple ones that are approved by the state. But you have to go attend it and make sure they get the paperwork filed with the court that you have attended. Okay? You have to make sure they file, I mean, if you go to the one here, I know they'll file the paperwork. They do it every time. If you go to one I'm not familiar with, I don't know if they'll send us the paperwork or not. That's going to be on you to make sure they file the appropriate paperwork with the court to show that you did attend and complete the program.
Okay.
So I would go to one that other courts are using. If you go to one that the court in Toledo is using, I would think they know the drill. They know what they have to file, and they just have to file it with a different court. Yeah, it's a driver's intervention program, so it'll be on your judgment entry that you have to do it. All right, anything else?
Not here, Judge, thank you.
All right, you have a right to make a statement if you want to, Mr. O'Malley, before I sentence you. Do you have anything you want to say?
Oh, Your Honor, just thank you for your guys' time, thank you.
All right, on your, and how do you want to treat this in terms of the fine on the refusal?
We'll leave that up to the court. I will say this, and I realize that it's inadmissible for purposes of guilt, but he blew a .095 on the portable breath test. So.
All right. Anything else you want to say about the refusal?
No, I was going to say I did blow on the side of the road, and then I was kind of confused at the police station, but I guess I probably should have done that.
Okay, I'm going to give you a $600 fine, so I'm going to give you a little break. And normally I give, you had a relatively low test score. Normally I give a $1,000 fine for refusing to take the test, but you did take the portable breath test, so we'll I'll be like Solomon and divide the baby in half here.
All right, thank you, Your Honor.
Some people like that, some people. I don't think he actually did divide. He threatened to divide the baby in half. Okay, so $600 fine and court costs. This will be a 6-month license. It's a first. It's a first.
Yeah, it'll be 6 months.
Yeah, 6-month license suspension. 20 days in jail, suspended. You got to do 5 days community service. You can do that in your home area. And a legitimate charitable organization, we need a letterhead from them saying you've done 30 hours of volunteer work. And you got to go to the driver intervention program. You can go to any approved program that the state of Ohio approves. So you pick it out, make sure it's approved by the state, and we'll give you credit for it. You got to get that submitted to the court. I'm going to set your review hearing for November 13th, so that gives you a long time to get all this stuff done. If you do get it all done by that date, you don't have to appear. If you haven't got it done, you got to appear at 9 a.m. on November 13th. Explain to me why you haven't got stuff done by then, okay? And then your probation will terminate once you've finished everything. I had a lane violation, I'll impose a $10 fine, and expired tags, I'll impose a $20 fine. And if you want to talk to the probation officer, you can call in the court, get a copy of your judgment entry. You can go online, the court has a website, you can pull up your case and see what you're ordered to do on the website. Lawrence County Municipal Court. All right, Mr. O'Malley, do you have any questions of me?
No, Your Honor, thank you.
You're welcome. Your next hearing is November 13th at 9 a.m. Get it done and you don't have to worry about it.
Thank you, Judge.
Okay.
State of Ohio versus Brian Stapleton, case number CRB 22573.
All right, Brian Stapleton was set as a trial today.
Judge, I think that we actually have an agreement worked out. My client has agreed to pay to Buckeye the sum of $900, which is what he owes them for service that he did use. And in exchange, the state would nullify the charge.
Okay.
First thing I would like to do, though, is see if Mr. Matt Workman is here.
Matt Workman, and also there was that was from the sheriff's office, the lawyer.
Yes. The number $900, I don't know exactly where that comes from. What's complained of in our case is that there were a couple months' worth that were not paid for because of tampering with the whatever, the transformer or whatever it is.
Meter.
The meter, thank you. And I didn't total it, but I have, let's see here.
There's also currently sheriff's fees and vigilant fees on the case of 16902, excluding the one take court costs.
So the total costs are going to be $226.92. Because there were sheriff's fees of $116.92.
The amount that we would be seeking is $910.41. And if that's paid within whatever time we determine to be reasonable, then we would agree to dismiss the charges.
My very important, I probably should use it, check it with the calculator, because my math skills are never that good. Yep, it was right. 11/27/33.
So what is that amount? 11/27/33?
Well, that's the total. Well, that's with court costs.
So 910.41 plus
216.92 was the court costs.
When would be a good date for us to come back, Your Honor?
When do you think he can pay it?
He said 30 days.
Okay, well, that's going to be May 15th, May 12th. May 12th, for some reason, kind of already getting booked. May 15th would be better.
15th is fine here, Judge.
Okay. And if he pays it, I'm gonna say he doesn't have to appear. If the money's already deposited with the clerk, case will be dismissed and he doesn't have to appear.
Okay.
If it's not, then he's gonna need to show up. He paid it to the clerk, all of it, to the clerk, not directly to Buckeye.
So pay it to the court.
That way there's a record of it. You'll pay it to the clerk.
So the theft is off of that, right?
It'll be dismissed then.
Okay. Because I can go to my grave and say I never stole a thing in my entire life. And this right here is pretty bad, you know.
Well, we can have a trial if you want to have a trial.
Well, I mean, if you dismiss them that I didn't steal anything.
You won't have a theft on your record, that's for sure. It'll be dismissed.
Okay. And I'll have this paid then.
So May 15th, and I'm just going to say as a pretrial, not as a trial. Correct. Pretrial be dismissed on payment of $1127.33 without the defendant being required to appear. If it hasn't been paid, he has to appear.
Okay. All right.
May 15th, 10 o'clock.
I'm sorry. Does the court staff know to whom to send this restitution of the money?
Buckeye Rural Electric Company.
Okay.
And they,
Thank you.
they will turn my electric back on, right?
Now, I don't have any control.
Okay.
Is it off now?
You too.
It may be that he owes other money, because we got indication that he had an arrearage on his bill in addition to this amount, so I don't know what he still owes.
That's going to train, they're not here today, so I can't speak for them. I don't know what their position is. I mean, we can reschedule it and try to have them here.
We made efforts to have our...
Was that Matt Workman, a person from Buckeye? Well, he came back, let me see the file. That subpoena came back. Return to sender, attempted, not known, unable to forward. 4848 State Route 325 South Patriot.
We also attempted to secure his presence by way of the attorney for Buckeye, who's Rusty Miller, and apparently he's out unreachable today. And we had a series of discussions about making sure to get him here. And we're hoping that he was just told by his employer to be here today, because we knew that we had not been able to perfect the service. However, if Mr. Stapleton's willing to agree to make this payment, I can't guarantee that covers every expense that he owes with Buckeye.
Yeah, so I don't know, do you want to have them here? Because I can't say, you may go to them, they say, we want $5,000 more. I don't know what they're going to say before they'll turn their electric back on. This is just the criminal case.
That's the only thing I owed them. That's why they turned my electric off.
Maybe we should reschedule it and require them to be here.
We don't oppose that at all, Your Honor.
Nor do we.
If you want an answer from them, they're going to have to be here. I can't speak for them.
I mean, they're not here. Any other time they get dismissed and everything.
Well, that's the thing. I can set, it was set for trial today. We can dismiss it if you want to go forward with the trial. But that's not going to get your electric back on.
Well, I'll pay them what I owe them, but that, I mean, I don't owe them, but that. But.
It was set for trial today.
For 3 months.
There's nobody here from the power company.
It was set for a trial on a previous day, and we agreed to a continuance from that day because the defendant requested it.
I had marked for today at noon for trial.
That's what I about.
It was also set for a trial on January the 20th.
That's true.
leaving back out on the boat. I'm leaving back out on the boat. I go back on.
You want to talk some more, Mr. Morford, and come back?
Yes, please.
Why don't you do that? I mean, if I call for trial, they don't show up, he's gonna win his case, but it's not gonna get his power back on him.
I understand the dilemma, Judge.
State of Ohio recalls Stephen T. Wells, case number TRC 222615, A, B, and C.
Okay, it is afternoon now, and this was set for noon today. And we had a couple of people that appears like they were subpoenaed to be here.
Judge, I think what's going on here, the other vehicle that was involved was a rental car owned by Enterprise. We don't believe there was any damage to it. According to Cogans who towed it, there wasn't any damage to it. As far as we know, Enterprise has it. There was insurance available had there been damage, but I don't think a claim was ever made because I'm not sure.
All right, well, I just want to make, there was two witnesses subpoenaed today, Phelan Boley and Brandon Freeman. So,
And, Your Honor, they were subpoenaed, however, I would not have been using them in the hearing because the focus of the motion was things that did not relate directly to their involvement, even though there was a collision.
okay, I just didn't want to go ahead and resolve the case and then they show up at noon and it's like, we were subpoenaed to be here. Oh, the case is over.
And I would let the court also know that we started early this morning trying to contact them by telephone and were not successful. We left messages.
All right, so apparently they're not that interested. So anyway, go ahead, Mr. Buell.
Well, Your Honor, given the totality of the facts as they're presented through the evidence that we do have, we feel that that it is necessary to compromise this case. Now, there was a refusal to take a chemical test, and that would result in a 1-year administrative license suspension. So that would be part of our agreement, and also our agreement would be for Mr. Wells to plead guilty to a reckless operation. And,
So we'll amend the OVI to reckless operation.
yes. All right. He's also got a marked lanes and a driving a four-wheeler on the road, so we would ask for a plea on those as well.
Okay.
Judge, Mr. Wells intends to enter no contest plea with a stipulation to facts sufficient for a guilty finding to those 3 charges.
All right, so the OVI is amended to reckless operation, and there's an unsafe vehicle and left of center, and he's entering no contest on all those.
That's correct, Your Honor.
With a stipulation to finding guilty.
That's correct.
Anything you wish to say, Mr. Wells?
No, Your Honor.
He also understands the issue created by the ALS, and that his license will continue to be suspended until, I think, October or November.
November 5th.
Yeah.
All right, I'll impose a $150 fine on the reckless operation, court costs. Then on the unsafe vehicle, $50 fine. On the left of center, a $20 fine. And does you need time to pay, sir?
Is this the 1-year license suspension for that?
It's for the ALS, for audio. Or, not, yeah, he had an ALS because he was used. No.
Judge, he's, does not probably have quite enough to do that today, although I think he can run home and get it. He can probably have it paid by the end of the week.
Okay, I'll give him a final pay date of July 11th.
Okay.
I'll pay it this week.
Additional suspension if he doesn't pay it by then.
It'll be paid this week.
July 11th, if you pay it after that, we've already been sent to the B&B for another suspension.
Okay.
And how much was it?
If he wants copies of the entries, he can get those from the probation office. I'm not putting him on probation. No.
Okay, thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Your Honor, there's now 3 still, so the cases really not set for, but set for review.
Okay, we can do it. All right. Well, then we can't do it. All right, Ms. Steele, your case is not set today. It's set for next week on the 17th.
I thought it was this week.
It's April 17th at 9 o'clock.
I thought it was April 11th.
Today's the 10th. So I don't have your file. We'll see you next Monday. All right. You're welcome.
State of Ohio versus Jeremy McMillan, case number TRC 22-769 A, B, and C, and TRC 20-2410 A, B, and C, and several more.
All right, Mr. McMillan is appearing today on his own, and he had missed a sentencing hearing on last Friday, I think it was. Yeah, Friday. So it's my understanding that you're willing, that you need and want to go back into treatment, is that correct?
Yes.
And OVP will take him? You've already checked?
Waiting right now.
All right, so I'm going to order that. You go to OVP, and then we'll set you for another hearing, just to check on you and see how things are going in 2 weeks on April 24th. All right.
Thank you, Honor.
All right, good luck, Jeremy. We'll see you in a couple of weeks. And it'll be sentencing. April 24th.
State of Ohio recalls Brian Stapleton, case number CRB 22573.
All right, Mr. Morford, how do you want to proceed?
Continue for 30 days, allow him an opportunity to pay the restitution.
Do we want Buckeye Rule to be subpoenaed in here or not? Is he going to deal with that on his own?
I'll deal with that.
Okay. Continue that, well, and that's basically what we had originally were going to do. May 15th, then I'll set it for another hearing May 15th. He doesn't have to appear if he's paid the 11/27/33. The criminal case will be dismissed. And then I'm leaving it up to him to work out whatever it's going to take to get his power back on.
Okay.
They're not here, and they're not actually before the court, so I couldn't order them to do anything even if I wanted to, because they're not before me. Okay?
All right.
All right. May 15th is the next hearing.
Thank you, Your Honor.
You're welcome.
Thank you. Appreciate that.
Okay, court's adjourned. Now, I've got a deposition to go to, so I'm not going to meet with the volunteers today. All right. Good to have you back, Margaret.
Thank you. I'm back for a while, and then I have to go get in there.
Thank you, Butch.
Did you have that fish?
Guys, we can't.
Oh, my gosh. Great time.
Did you get that?
On what?
Oh, that's right.
Oh.
I think you told me